Hi, everyone. I'm immigration lawyer John Khosravi. Thank you for joining us today. We're going to have an in-depth and detailed discussion about the process for applying for a green card in the United States. It's called adjustment of status and using Form I-485. It's a USCIS Immigration Department form. We're going to analyze what the form is, what's required to be able to do adjustment of status, and all the other big and small questions that pop up regarding that process. Stay tuned. Thanks again for joining us. So the topic of adjustment of status is a big one. It's complicated. So first and foremost, I do recommend consulting with an immigration attorney after viewing this video to get a proper understanding how this process works for you and if it's appropriate. There's a lot of little things that we have to review to make sure it's good. And we'll talk about some of those here so you get an idea of what I'm talking about. So adjustment of status, what's it about? Well, it used to be before like 1950, that if someone was in the United States and they wanted to apply for a green card, they would have to leave the United States, apply for an immigrant visa, then come back in and get the green card. That process still exists. It's called consular processing. We'll do a different video about that for people who need to go through that. But they realized it's really difficult for people to go through that process. So they created adjustment of status so people could apply for the green card while they're in the United States. And the main statute is under the Immigration and Nationality Act, Section 245. That's where it breaks down what the process of adjustment of status is. But if you want to apply for a green card in the United States, the requirements are much higher. So if you have certain mistakes or violations, you won't be able to apply for adjustment of status. In some cases, you can still go to the embassy, get the immigrant visa, and come back in. They just are more stringent, and they won't let you apply for it in the United States. So as I said, the form for applying for adjustment of status is Form I-485. You send that into the Immigration Department, but you can't just send that in on its own. There has to be a companion petition that goes before that or along with that. It could be a family-based case, Form I-130. It could be an employment-based case, Form I-140. And so it depends on if those cases are going with it and if the priority date is available for those cases. And there's a separate video that talks about what priority dates are and the timelines for this stuff is. But essentially, if you're applying for a green card from within the United States, and it's a green card based on being a parent of a U.S. citizen, spouse of a U.S. citizen, or minor child of a U.S. citizen, you can file Form I-130, the family petition, along with I-485 together. But all the other types of family cases, you need to file Form I-130 first, and that priority date needs to become current before you can file for adjustment of status. And again, that discussion about what current is related to the visa bulletin charts and the USCIS interpretations of those. There'll be a separate video that goes into that analysis because that requires its own attention. It could get confusing. If you're doing a work-based green card, I-140, it goes along the same, and sometimes I-360 as well, the EB-4 category, VAWA, and the rest of the cases. You got to analyze what those are. We'll have a separate time for that. But let's say it's time for you to file Form I-485. What should you do first? Well, first and foremost, you have to see whether you could even use the adjustment of status process. Under that code section I told you about, INA Section 245, there's a part that's written INA 245C, and it breaks down several criteria or issues that could pop up that could prevent someone from applying for a green card within the United States. And the most typical of that one is whether they enter the U.S. lawfully or not. Actually, that's under 245A, the first portion. To be able to apply for adjustment of status in the United States, you need to have lawful admission or parole. And that becomes really important because for those who enter the United States without permission, they cannot apply for a green card while in the United States. I get a lot of calls from people who are U.S. citizen children. They say, I want to get a green card for my parent. Could I do that? Well, if the parent did enter lawfully, which sometimes they don't, they cannot apply for adjustment of status in the United States. That's forbidden. Now, there are exceptions to this. One is called the 245I exception, which says if that parent, that person who came in without permission, had a green card application started for them in the 1990s, and there's more details and nuances to that, they could potentially be forgiven for that. And there's other special exceptions as well for someone who entered without permission to be able to file for a green card in the United States. Because they're so unique and special, you really need to contact the immigration attorney to see if they apply to you. It could be, for example, a thing called TPS, Temporary Protected Status, for people in certain parts of the United States. Not every section of the United States could do that, but that's a discussion for another time. So if you did enter lawfully, either were paroled in or had admission lawfully, and also if you did not do any immigration violations, you didn't work inappropriately without permission, or you didn't overstay a visa and you have a clear history of that, you could apply for adjustment of status. Now, again, there's exceptions to that too. So let's say you're an immediate relative, the spouse of a U.S. citizen, parent of a U.S. citizen, or minor child of a U.S. citizen. If you overstayed a visa or you work without permission, they forgive that in the adjustment of status process. But that doesn't work for spouses of green card holders, other relatives of green card holders, or even other relatives of citizens, like brother and sister cases or adult children of U.S. citizens. This forgiveness of overstaying a visa or working without authorization is only forgiven for immediate relative cases. There's another exception for that, though. If you're doing an employment-based EB1, 2, or 3 category, applying for green card, there's a section called 245K, which forgives overstaying or unauthorized employment up to 180 days. That gets more nuanced too. So if that situation applies to you, you should consult with an immigration attorney for guidance that's appropriate to help your case. But okay, that was the analysis. There's more to INA 245C that breaks down whether you could apply for a green card holder adjustment of status in the U.S. or not. But typically, the big ones are those: whether you whether you work without permission, overstayed a visa. Those would get most people. So that's the primary analysis when we first talk with somebody. We look at to see if they could do adjustment of status. So let's go further now. So let's say they're appropriate to file adjustment of status. What's the next step? Well, we start analyzing based on the form and the questions that pop up for a thing called inadmissibility. We have a separate video that discusses inadmissibility issues that is really important to watch out for. But inadmissibility is, having certain criminal violations, health violations, personal life, if you're polygamous, for example, so all sorts of other stuff. We did a video that you could check out on that one as well that'll go into more detail about that. But if you don't have those, then I-485 is appropriate. If you want to get some better understanding of what those questions are, first of all, INA 212 is a section that goes over that. But the form I-485 itself has almost like 10 pages of questions that are yes or no, and it'll give you an idea what you're looking for. Those questions are still not thorough. They still miss some stuff that could be problematic. That's why it's best to do a full analysis of your case history or personal background before filing for adjustment of status. So let's talk about Form I-485. Form I-485 is required for each person that's applying for adjustment of status. So let's say you're married and you have kids and you get the chance to get a green card within the United States. Each family member has to file Form I-485 adjustment of status. And that form goes over a lot of your biographic information as well. So it goes 5-year employment history, 5-year residential history, all the names you've used, and then all those questions about your background. Have you been a Nazi? Have you killed somebody? Have you ever overstayed a visa? Have you violated your visa status? They go into all of it to see if it's a problem. For example, some people might have gotten a J1 visa. J1 has this one special novelty part of it that says if you had a thing called a 2-year home residency requirement, you cannot apply for adjustment of status unless that's been waived. Again, these are the nuances we need to analyze because not most people don't have a J1 visa, but if you did, we got to make sure to see if that problem applies to you. And there's a myriad of things just like that that could be prohibitive. So for I-485, you complete it. Along with that, you need to attach a lot of documents. So one are your civil documents. So this could be your birth certificate, your passport, proof of lawful entry or admission. So you need to show the visa and the stamp you got on your passport, your online Form I-94, which you can get on the Customs and Border Protection website. If you were paroled in, proof of the parole entering the United States. So again, they want to see that you enter lawfully, as I said in the beginning. That's really important. And then the proof of your background. So your birth certificate and passport as ID, both are required with translation if needed. And along with that, any other things that are part of your biographic background. If you're married, divorced, name changes, all that kind of stuff should be submitted so the government has a good picture of you. That's the basics of Form I-485. Now, again, there's nuances. If you're using 245I, you need to show some other paperwork as well. That's something you should consult with an attorney about. But the next part of Form I-485, if you're doing a family-based case, is the Affidavit of Support. Now, I'm going to do a whole separate video on that because that's its own topic. But if you're doing a family-based case or an employment-based case and the employer that's applying for you is a relative or someone that's close to you, you need to file a Form I-864, Affidavit of Support, to prove there's someone that's going to financially support the United States, and that goes into law too. There's also a new thing that started in February 24, 2020 by President Trump's administration called under the Public Charge Rule, Form I-944, a Declaration of Self-Sufficiency, and that's something that's, while I'm recording this, is on temporary hold, and that's a whole topic that will require another video, but that may be required as well. Now, In addition to Form I-485, when you file that, you could also apply for a work permit with it called Employment Authorization Document, EAD, and also permission to travel called Advanced Parole Travel Document. Because when you file Form I-485, you are not allowed to travel internationally. If you leave the United States, that abandons your application, and you don't want that to happen. So you definitely want to get that advanced parole permission if you need to leave. Now, it takes a while to get that permission. You can submit the Form I-131 to get that travel permission. It could take many, many months. If there's an emergency situation, you could potentially ask USCIS to expedite or in an emergency basis issue it to you. That's a complicated thing. They've gone harder and harder, more difficult to do that. But that is possible, along with the EAD, Form I-765, the work permit. If there's a need that's appropriate, and you got to decide what is appropriate, what's not, it's better to talk to a lawyer to see if it's not going to harm you by saying that information. But you could file for Form I-765 along with that. Now, as I'm recording this, there's no additional fee to file for the work permit travel permission, but October 2nd, there's going to be a fee increase. So you should always go to the USCIS.gov websites for each of these forms and see what the current fee is and also what the current mailing location is. The mailing location will be based on Form I-485. That's a primary application. So all these additional applications should be included with that package and mailed based on the address for the Form I-485. But check the fees, filing locations, which edition of the form is required, all that kind of stuff before filing it. It becomes really important to do something like that. So you say you file Form I-485, it's pending. What happens? Well, first you file it, and then hopefully a few weeks later, you get a receipt in the mail that has your case numbers for the I-485, the application for adjustment of status, and if you file for a work permit travel permission, separate receipts for those. There's no receipt for the I-864, just those three. And if you do the I-9442, there's no receipt for that. And then you wait for eventually doing a fingerprint. Eventually that happens, then you wait some more, and probably will have an interview. Now, in between, two things could happen. There's also a medical checkup requirement that's part of the Affidavit adjustment of status I-485 that you need to complete by going to a civil surgeon. It's a registered doctor that can complete Form I-693. It's a medical checkup form to see if you have tuberculosis, gonorrhea, syphilis, if you have any mental health issues, if you have any other problems, drug abuse, and that you've gotten the vaccines that you need. A doctor needs to complete this, put in a sealed envelope, and give it to you so you can either submit it with the application or do the medical checkup afterwards. Now, after recording this, the government may change the rules on whether you could submit it afterwards or bring it to the interview. But as of the recording of this, you could submit afterwards, and most of the time, I just have clients do it later. That's a big part of it that you need to be mindful of is the medical checkup with the civil surgeon, which if you don't submit with the original application, you'll get a notice in the mail as a reminder to bring that with you, or notice that says, please mail it to us. Because the next step would be an interview, and not all cases require interviews. If USCIS feels that an interview is not needed, then they'll ask you to mail the medical checkup to them. So that's the situation. I'm between if USCIS feels some documents are missing, they could either just deny the case, that's a new rule under President Trump, or hopefully they'll just send you a letter saying, we feel these documents are insufficient, please send us more documents so we could check that out. And that's something you could do as well. That happens. So that's called a request for evidence, RFE. And if that happens, you just submit those within the time allotted to the government so you can satisfy that requirement. And then eventually either you have an interview and you go to the interview at the local field office where you're living. It's based on your address or whichever office is least busy around you. Or if no interview is needed, you just get the green card in the mail. Now let's kind of dive into some parts of this because it made it sound too easy. Unfortunately, USCIS is never that easy. So there's a lot of times where you submit the documents and they come back and say it wasn't there. That happens. That happens more and more frequently every day. So be prepared for something like that. Or something that happens a lot is you send the birth certificate and they come back at you and say the birth certificate was incorrect when it was correct. Or they'll say you didn't send the birth certificate, but you did. Hopefully they won't deny the case. Nothing much you can do. You just submit it. Another part where that happens is the affidavit of support, the financial documents. You send everything in, everything's cool, and they come back and say you didn't send anything, or the money you make for the affidavit of support is not enough, when in actuality, it is. Those kind of problems happen for everybody, unfortunately, but hopefully you just did the documents right, so it's not really your problem, you can fix it up. But those are things that I do see happening frequently enough to mention it here. Now, along with the application for adjustment of status, there's also passport photos that you have to submit. It's 2 for the application for adjustment of status and 2 for the employment authorization document. To be safe, I just throw another 2 in there for the advanced parole, even though it may or may not be required. You should always read, if you're doing this on your own, consult with an attorney and review the instructions for each of these forms, because they frequently change this stuff up. So there's little things I could be saying here with regard to the passport numbers or how the signature should be that get changed up, or a new form edition comes that has more questions that were not previous there. So you got to be mindful and be watchful of these kind of things as they pop up. But those are some things that happen. Now, eventually, if an interview does happen, many times it's with family-based marriage kind of cases, you'll get a notice to appear at your local field office by USCIS, and you should go there that day. You do an interview in person. They ask you biographic questions to make sure the information on the application is correct and everything matches. May ask you about the basis of your green card, what the family relationship is, what the work is, and all that kind of stuff. And the goal is to see who you are and whether it's appropriate for you to apply and get a green card, or you should be denied. So the main thing is you really want to do your homework before you even start, before you go on the record, because you don't want to spend all that time, all that money, and the filing fees will keep going up, as well as the risk of identifying yourself for the government, getting denied, and potentially being removed from the United States, or being sent to removal proceedings to immigration court for deportation. You really want to do your homework beforehand to make sure that's okay. And one example where people on their own do it's a mistake is some countries have a program called the Visa Waiver Program, or ESTA. I think it's Electronic Something Travel Authorization. You can check, you can see what it is, the full name it is. But the point of this is they allow certain people from certain countries like Japan and Western Europe and Australia to come to the United States without applying for a visa first. They just go online, fill out this quick form, and they're able to come to the United States for 90 days and leave. If someone comes with that visa, they traditionally, and for the most part, cannot apply for adjustment of status in the United States on ESTA, or the Visa Waiver Program. You know, and sometimes when people apply on their own, they don't realize that they apply, and then they get denied, and as soon as they get denied, they could get picked up and put on a plane and sent back to their home country and be banned from coming potentially. So that's something to be very careful of. Now, there is an exception for this. If you are doing an immediate relative case, you've mentioned this before, this immediate relative case of being a parent of a U.S. citizen, the spouse of a U.S. citizen, or minor child of a U.S. citizen, it's a very powerful thing. If you have that kind of case, you can apply for adjustment of status in the United States. It's a risky thing it's not that risky, always get approved, but you know, it's bordering on risk. And in those kind of cases, you can, but other people, you know, spouses of green card holders, employees of companies, they cannot file for adjustment of status in the United States. So be careful. You do not want to make that mistake and have that be the reason why the case is denied. So one other thing I do want to mention, if there's criminal history to a case that could be problematic, you really want to study that to make sure what the situation was so it's not issue. This goes back to the inadmissibility stuff, INA 212, which is a separate video, could help you get a better understanding of that. But if you feel like there's some issues, you should definitely consult an immigration attorney. It could get complicated. And the last thing I would want is you to have an issue with the immigration department over something like that. So that's about it. So Form I-485, it's deceptively simple, even though when I started practicing, it was only like 4 pages. Now it's 20. It's probably going to go to 25, gets longer and longer. There's a lot of questions. Make sure you read each one of those questions in detail and answer appropriately. You don't want to not mention stuff that should be mentioned. No, and be mindful, if you, unless you're an immediate relative, if you have had previous visa violations in the past, that's another reason why you could be prevented from adjusting status. For example, I had one person that would come to the U.S. on a tourist visa just to hang out, but the guy was also doing YouTube videos and getting paid by YouTube, you know, just doing videos. A popular kind of guy. And that's a violation right there. So if he was going to apply for a green card based on marriage to a green card holder, they would have denied it, saying you had unauthorized employment in the United States, you cannot adjust for status. However, if he had married a U.S. citizen, that would have been okay. It's forgiven for spouse of U.S. citizen. In this case, he applied for a work-based green card, and even though he had unauthorized employment in the United States, for EB1, 2, and 3 categories, there's that 245K exception, which permitted him to apply for the green card within the United States. So it gets a little challenging, and that's one of the reasons you should consult with an attorney about this. I have so many more examples of this kind of stuff. Another thing to be careful of is misrepresentation or fraud. What you say in the green card application should match what previous visa application said. So if you had a tourist visa in the past and you said one thing, you said these are my names, these are the countries I've been to, or passports I have, or the history I have, and military history, all that kind of stuff. If then you don't mention that or is different than what's in the adjustment status application form I-485 and the attached documents, that can be problematic. They can accuse you of fraud and misrepresentation, and that's a very serious matter. And I mentioned military history. You want to be careful, make sure you have the documentation for that just in case they want to ask about it. So there's a lot more information we could talk about, but this video has already gone long enough, I'm sure. For those who are still watching, you got your handful of information. If you want to schedule consultation, please email my office, info@jqqlaw.com. You can schedule a time and download. There's an ebook for those who are doing the marriage process, www.marriageimmigrationlaw.com/ebook, which has a great synapse. I think it's the best one out there. I call it the Ultimate Marriage Green Card ebook. And even for those who are not doing marriage cases, other than the one portion of it that's related to fiance and marriage cases, the rest is pretty much the same. So you could use that booklet as well. I'll probably separate and create a sub-booklet just for everyone else. But I really wanted to talk about this process from I-485, what it means, what it entails, and just to give you an initial understanding of what you're getting yourself into when you're doing this, and hopefully, help you out to avoid some of the problems that I do see happen. Thank you so much for listening. I wish you all the best, and I hope you're able to get your status. Bye-bye.